Hi, welcome to My Court Coach. I'm Jaylin and I'll be your instructor as we navigate through the form DV160, Request to Keep Minors' Information Confidential. So we are only using this form in the domestic violence context, meaning that if you are a parent or the minor child or the legal guardian, then you are the only three individuals that may be able to use this form to keep the child's information confidential from the public. Because restraining orders, domestic violence restraining orders, are public information. So anybody that has a name is able to look up the restraining order and find their address, where they live, their phone numbers, and some other personal information. However, if it is a child that is requesting the restraining order, you're filing a restraining order on behalf of a child, then you can use this form to keep their information confidential from the public and even the restrained party. However, you do need a mailing address because the other party, as well as the court, should be able to reach you and or the child relating to the restraining order matter. So you could obtain a confidential address from the Secretary of State, and there is a separate video about the address confidentiality and how to obtain that. So if you are the parent or child filling this out, then you would write your name here. And it's actually the person who's requesting the restraining order, so you would list the name of the child here, and then the name of the other party, and then the person that's requesting the confidentiality, which can be the legal guardian or the parent or even the child. That name goes right here. And then you would identify who is filling this form out, and then all the children that are requesting their information to be confidential from the public, their information would be needed to be listed here. And then if we need to write more of the children's names, we can fill out this form called MC025 and write on there that this is DV160, and you could write out the children's names here, or in fact use this and copy it and paste it on to, well, you can't copy it from here, but you can go ahead and copy it and write that notation right here. So the contact information of your lawyer does need to be on this form. If you do have an attorney, so make sure that your attorney or yourself does complete that area. And then request for more than one minor. So maybe all of the minor children do not need the same information removed from the restraining order packet to be kept confidential. And if that's the case, then you're going to check off the second box because you're saying not all of the children need the same protections. But if all the children do need the same protection, then you would list you would check off the top portion. So what is the information that you want to be kept confidential? And you must remember that if you are having different requests for different children, then you will need to fill out this form, or at least this attachment MC025. You need to make sure that you fill out this section 5 for each child separately. So information to be kept confidential from the public, you would just go ahead and write that here. And then I would just write the child's name as well so that the court is aware which child you are talking about. And so you would go through and write in, I want the information checked below to be made confidential and not available to the public. So the minor child's name. And so if that's the case, the public will not have access to this name in the case, but the restrained person and law enforcement must be given this information. The minor's child address, so that will be kept confidential. And it says you do not have to make this request for using a mailing address that does not need to be kept confidential. Use that mailing address on all forms in this case or any other civil case. And then if there's not enough information for each child, then like I said, you would go ahead and use this MZ025 to include that information. Then we could exclude specific information relating to the child. So it says here that the public will not have access to the information, but the restrained person must be given the information that is necessary to comply with the restraining order and to respond to the restraining order request. So describe all of the information that it will be filed that you want kept confidential. So you have to, the court, lists this part right here, makes this notation right here, because you have to keep in mind that when you're filing a restraining order against the abuser, they have to be able to respond. They should have a fair opportunity to respond. So the information that you are keeping private should be information, in our opinion, information relating to their social security number, for example. They don't necessarily need the child's social security number in order for them to respond properly to the restraining order. So it's information like that, like maybe identifying information that you had written in the restraining order that you do not want the other party to know, or even the workplace of the minor child if the child is working somewhere, or even the cell phone carrier of the child if you don't want the other parent to subpoena the records, for example, of the minor child. So information like that is not necessary or crucial for a domestic violence restraining order and is not needed to properly respond to the restraining order. So you can ask the court to redact that sort of information. And it tells you right here that you do need to include the form number. So if it's a DV100, the page number, like page 3, the paragraph, it could be paragraph 27, and then the line number that's written on the form, or the attachment number, or the exhibit number. So as specific as possible, you would need to make sure that you include that information here. And then information to be redacted. So if you had written in there that the other party took the social security card number of 60352132 as and ripped it in 2 pieces and threw it at the minor child, then you would want the court to redact the information only related to the actual social security number. So that is something that you could use here as an example as to what information should be redacted. So what that means is information that's not going to be reviewable by the public. And the court does want you to circle all the information that you want confidential. So not only is it going to be listed on this form specifically, but you will need to circle that information. So the court does have it essentially twice. And then if you need additional space, then you use this attachment to the judicial counsel form. So reasons for your request. So in order for the court to approve your request, the court must expressly find all of the following: that the minor's right to privacy overcomes the public right to access the information. So what that means is that the child's right to privacy, so they must have a privacy right over the public having the right to the information. So going along with the example of the social security number, the public does not have a right to the minor's child's social security number at all. And so that child's right to privacy does extend beyond the public. Then there's substantial probability that the minor's interest will be prejudiced if the information is not kept confidential. And that's very easy as well, because there is a possibility that somebody might use his social security number to do an identity theft, or maybe the other parent or the other party is known for identity theft, and therefore you don't want them to take the social security number and use that against the child, and therefore that is leaked to the other party or to the public, then that child risks that probability of being prejudiced. And that prejudice is identity fraud, for example, if that actually ended up happening to the minor child. And then the order to keep the information confidential is narrowly tailored. So when we're saying we only want the social security number to be removed, but not necessarily that whole entire sentence, then the court is finding that, or should find that, to be narrowly tailored. And then there is no less restrictive means that exist to protect the minor's privacy. So there is not going to be a less restrictive means, hence why you're asking the court to keep it confidential, because now when you filed your restraining order, you have made it public, and there is no other way to remove it other than to ask the court specifically to redact that information. Because other ways to amend, let's say you filed something and then you're like, oh no, I didn't know that the other party was actually going to receive this, and I don't want them to receive this. So instead of, canceling your entire restraining order, you can ask the court on behalf of the child to remove certain line items. But if you didn't do that and then you wanted to refile the restraining order, you wouldn't necessarily be able to refile, but you would be able to amend or supplement your restraining order. But it doesn't remove the information that you want to be kept confidential for your child. So this form is very crucial in order for you to ensure that the privacy of your child is kept confidential and kept private. So you would need to explain all of that here. Like, why should the child provide an item 5 to be kept private or confidential from the public? And as we went through the Social Security example, this is something that you could write in here just to explain, and make sure that you use each of these elements, that's what we would call them, each of these 4 points, in your response. So, you'd write the first one there, and you would state that, your request is for the Social Security number to be removed, and nobody has the right to another individual's Social Security number. And so the minor's right to privacy is superior than the public's right to access that information. And you'd say the same thing about the second element, and the third element, and the fourth element. So you would make sure that you would write that here, and if you needed more space, which I'm sure you would go ahead and use this attachment to the Judicial Council form. So what do you think would happen if the information was not made private or confidential? And so if the other party has a history of identity theft, this is a perfect spot to write that in there, is that they have a history of that, and therefore you're in fear that the other party would do the same to your minor child. Or if the public had that information, this is private information given the political climate or something like this, and therefore you want that information to be kept private. So if any portion of the request for the confidentiality from the public is denied, what would you want to do? You want to cancel your restraining order. And if you cancel a restraining order, that means you're not receiving a restraining order at this time, but you can file a request on the same or different facts at a later time. Or you can move forward with your restraining order. So you ask the court to make the decision on your restraining order. And this essentially means that all the information in your request for the restraining order and other related documents will be available to the restrained party and to the public, and nothing is kept confidential. So depending on the necessity to remove, for example, that Social Security number, you're going to check off one of these 2 boxes. And this is a personal decision, and it's best to err on the side of caution and perhaps cancel the restraining order and just remove the information that you do want removed from the restraining order packet. That's a much less of a hassle than having to move forward with your restraining order and dealing with whatever consequences that might lead to if it is leaked to the restrained party or the public. So information to be kept confidential from the restrained person. So the restrained person must be given information necessary to comply with the restraining order and to respond to the restraining order request. And again, very important, because that is the court's main concern. And so long as you're able to maintain that concern or alleviate the court's concern for that, if they're able to respond to your restraining order request properly without that information, then the likelihood of the court granting it is pretty high. So you don't want the restrained person to have access to the information checked in item 5 what information do you want to be confidential and not give to the restrained person? So if it's their address or their name or any other information. And again, if you needed to add more, you could go to this MC025. And then why should the information listed be kept confidential or not given to the restrained person? And then you would have to, again, write why. And if you need more space, you would go to MC025. And then what do you think would happen if the information listed is given to the restrained person? And if you need more space, then you would write that also in this MZ025. And this information, I mean, it's pretty identical to what you'd write in A and B. So you can just essentially rewrite it and reword it in a way where it is specific to the restrained person. And that should be enough or should suffice to file this form. So the court again asks if any portion of your request for the confidentiality from the restrained person is denied, do you want to cancel your restraining order or move forward with it? And our advice on that is to cancel the restraining order because it is much of a less of a hassle for you to redraft the forms that you have with the same facts and then you on your own redact the information that you want to be kept confidential versus dealing with any consequences that might arise from the other party or the public having the information that you really needed to be confidential for your child. And then you say how many forms are attached to this form and you sign it. I hope that this was helpful and good luck.